I want you to take a deep breath and listen carefully, because what you're about to hear could shape your future in the United States for years to come. If you are waiting for a green card, planning to apply, or even thinking about moving to the US, there are major immigration policy signals being discussed right now that could change who qualifies, how long it takes, and what options are still available. Many immigrants are already panicking because of headlines, rumors, and social media posts saying everything changes on January 1st, 2026. In this video, I'm going to calmly walk you through what is being reported, what is officially proposed, what is not yet law, and what you can do right now to protect yourself and your family. Let me be very clear from the beginning. Immigration law in the United States does not change overnight just because of a headline. Even when a president announces plans or approvals, there is a process. There are agencies involved. There are timelines. And there are still legal pathways if you understand the system instead of reacting out of fear. This is Legal Focus USA, and my job is to help you understand U.S. immigration in plain English, without panic, without politics, and without false promises. Right now, there are widespread reports and official policy statements connected to former President Donald Trump's 2026 immigration agenda, including major proposed changes to green card rules if those policies are fully implemented. Many media outlets are using the word approved, but legally speaking, what we are seeing are policy frameworks, executive priorities, and draft rule directions that are intended to take effect starting January 1st, 2026, if enacted through proper legal channels. So let's slow this down and go step by step. First, what is actually being discussed? According to official campaign documents, policy advisors, and transition planning materials, the Trump administration's 2026 immigration plan focuses heavily on what they call merit-based legal immigration, stricter eligibility screening, and reduced discretionary approvals. This directly affects green cards, because green cards are the foundation of permanent residence in the United States. One of the biggest proposed changes involves employment-based green cards. Under the proposed rules, priority would be given to applicants with higher education, specialized skills, advanced English proficiency, and U.S.-based job offers in critical industries. This means applicants with STEM degrees, healthcare experience, engineering backgrounds, or high-demand technical skills may move faster, while others could face longer wait times. Let me give you a real-life example. Carlos is a software engineer from Mexico working in the U.S. on an H-1B visa. Under the proposed framework, someone like Carlos would likely benefit because his skills match what the U.S. labor market needs. His employer-sponsored green card could move faster if merit-based scoring is applied. Now compare that to Maria, a hospitality worker from the Philippines. She has legal status, works hard, pays taxes, but does not hold an advanced degree. Under these proposed policies, her green card pathway could become more limited or delayed, not because she did anything wrong, but because of how the new system prioritizes applicants. This is why understanding the details matters. Another major proposal affects family-based green cards. Current law allows U.S. citizens and permanent residents to sponsor certain family members. The 2026 policy proposals suggest narrowing family-based immigration to immediate family only, meaning spouses and minor children. Adult children, siblings, and extended family categories could face tighter restrictions or longer backlogs if these changes are implemented. For many immigrant families, this is the most emotional part. I want to share the story of Amina, a U.S. permanent resident originally from Nigeria. She has been waiting to sponsor her adult son for years. Under the current system, the wait is already long. Under the proposed changes, categories like hers may become even more uncertain. This doesn't mean applications will suddenly be canceled, but it could mean longer processing times or stricter eligibility rules going forward. Now let's talk about another topic that is causing fear online: January 1st, 2026. This date is being widely mentioned because it aligns with the beginning of a new fiscal and regulatory year. Immigration agencies like USCIS, DHS, and the Department of State often roll out new rules at the start of a year. If a new administration is in place and has finalized regulations, that is when changes typically begin. But here is the key point: many videos are not telling you. Nothing automatically changes on January 1st unless regulations are finalized, published, and legally enforced. That process includes public notice, internal agency guidance, and sometimes court challenges. Immigration law is slow, even when politics is loud. Now let's talk about green card security, because this is where many people are scared. If you already have a green card, proposed 2026 policies do not automatically take it away. Permanent residents still have constitutional protections. However, the proposals do include stricter enforcement of residency rules, travel limits, and review of abandonment issues. For example, green card holders who spend long periods outside the U.S. without proper re-entry permits could face more scrutiny. This is not new, but enforcement could become stricter. I want you to imagine Raj, a green card holder from India who spends 8 months a year outside the U.S. caring for family. Under stricter enforcement, Raj may be questioned more aggressively at the border about whether the U.S. is truly his permanent home. The solution is not panic. The solution is planning, documentation, and legal guidance. Now let's talk about something very important: processing speed. One of the stated goals of the 2026 immigration agenda is faster decision-making. That sounds good, but faster does not always mean easier. Faster can also mean quicker denials if applications are incomplete, inconsistent, or poorly prepared. This is why legal preparation becomes more important, not less. Another area being discussed is public charge rules. While nothing has been finalized yet, there are strong signals that financial self-sufficiency requirements could become stricter again. This could affect green card applicants who rely heavily on certain public benefits. For example, Elena, a green card applicant through marriage, worries because she used temporary assistance during a medical emergency. Under stricter interpretations, applicants like Elena may need stronger financial affidavits and documentation to avoid delays. Again, this does not mean automatic denial. It means preparation matters. Now let's talk about what has not changed. As of today, the law governing green cards is still the same. USCIS is still processing applications under existing rules. If you are eligible now, waiting out of fear could actually hurt you. One of the biggest mistakes immigrants make is delaying a strong application because of rumors. If you qualify today, today is often the best time to apply. This brings me to an important step-by-step mindset I want you to adopt. First, separate confirmed law from proposed policy. Headlines are designed to scare you. Laws are designed to move slowly. Second, understand your current status. Are you on a work visa, family visa, student visa, or undocumented? Each category is affected differently. Third, if you are eligible for a green card now, delaying could expose you to stricter future rules. Fourth, documentation is everything. Strong evidence, clear history, and consistency protect you regardless of who is in office. Fifth, stay informed through reliable legal sources, not social media panic posts. Let me tell you about Daniel from Brazil. He qualified for adjustment of status through marriage, but kept waiting because he was afraid new rules would block him. When he finally applied, processing times increased. Had he applied earlier, his case would likely already be approved. Fear delays more green cards than law ever has. Now, I want to address immigrants watching from outside the United States. If you are planning to apply for a green card through employment, family sponsorship, or the diversity visa program, proposed 2026 policies may increase competition, but do not eliminate opportunity. The U.S. economy still relies on immigrants. That reality does not change with elections. What does change is how selective the system becomes. Now let's talk about hope, because this is not a message of doom. Every administration proposes changes. Courts review them. Agencies interpret them. And immigrants continue to build lives in the U.S. Even under stricter systems. People with strong cases succeed every day. The key difference between success and failure is not nationality. It is preparation. I want you to hear this clearly. If you already hold a green card, focus on compliance and documentation. If you are applying now, apply correctly and completely. If you plan to apply in the future, start preparing early. If you are unsure, get reliable legal guidance. Do not let fear make decisions for you. As we move closer to 2026, we will continue to monitor official rule publications, USCIS policy manuals, and Department of State guidance. When something becomes law, we will explain it clearly. Until then, do not let headlines control your life. If this video helped you feel calmer and more informed, I invite you to subscribe to Legal Focus USA. We break down immigration changes step by step in simple language so you can make confident decisions for yourself and your family. Turn on notifications so you don't miss important updates, because timing matters in immigration. Thank you for trusting us, and I'll see you in the next video.